Good morning, and thank you for inviting me to deliver a presentation in this international seminar. It is a very difficult mission because the topic I chose for the beginning of the seminar is the position of the notary between the tax law and the succession law. It is a difficult position we have in our capacity as legal professionals. Lately it has acquired more and more significance in the implementation of the tax legislation. For the beginning, I would like to examine a bit the European tax system and to analyze the impact of the implementation of the new regulation in matters of international succession and how our activity has already changed in the matter. As you know, the legal developments have been quite difficult. International succession have been discussed for almost 6 years. It started in 2009 with the Commission's proposal. Then Regulation 650 was published, and finally in 2014, Regulation on the enforcement of the regulation on international successions was approved. Currently, we may say that international successions had been eventually regulated and that this regulation was a uniform regulation at the level of the member states, but we should wonder to what extent was it uniform. We will see during the seminar that in the matter of calculation and payment of taxes, the national legislation is still the applicable law. This may be easily found by reading the regulation. Assumption number 10, which says that the state will decide whether the transfer of goods will involve payment of fees or taxes. Another element related to the taxes on the succession is the recommendation of the Commission from 15 December 2011 to avoid double taxation. I should emphasize that this concern to avoid double taxation had been on the European Commission's agenda since 1994 when it targeted the small businesses, but with Regulation 650, this concern was extended to the matter of successions. At EU level, it was found that the incomes of the EU member states from taxes on succession would amount for less than 0.5% of the total tax revenues, and obviously the cross-border cases have a much smaller contribution. We should also analyze the principle of fiscal sovereignty, which is an element of the national sovereignty, and direct fiscality falls under the scope of each member state that would exercise it pursuant to the community legislation. Also, the member states do not have the obligation to eliminate double taxation within the European Union. A few words about the European fiscal order. First of all, succession falls under the scope of movement of personal capital. Therefore, the Court of Justice of the European Union decided that the fact that cross-border successions are on the list of nomenclature it makes them, to the extent as their elements are not limited to one member state, these successions fall under the notion of free movement of capital, currently governed by Article 63, paragraph 1 from the Treaty on the Functioning of the European Union. Hence, we conclude that certain measures or provisions in the tax legislation of the member states may be considered incompatible with the free movement of personal capital. Therefore, the consistent practice of the Court of Justice of the European Union shows that, or bans measures whose effect would be to reduce the value of the succession belonging to a resident from another state than the member state where the goods or the property is. The best known case is a case against Belgium. The court found that the measures provided by the Belgian state and in the case related to charities which did not have their headquarters in Belgium or in the state of residence of the deceased, and had they had their headquarters in Belgium, would have benefited from lower taxes, namely 7%, compared to a share of almost 80% in the case where the charity did not have their headquarters in Belgium. In this case, they considered this provision from the Belgian tax legislation would breach the free movement of capital. Also, the existence of rules according to which goods which are part of the property of the estate, they should be identical regardless their location. In the decision passed in the case C-206 per 2006, the court found that if the good located in the country of residence, there would be a reduction of the value considered of almost 90% compared to the 100% evaluation, 100% of the market value for property located in a different state. By this measure, the German state breached the free movement of capitals. Also, if there is discrimination in the country of origin by applying a lower deduction based on the location of the real estate, we give the example of case C-181 per 2012. In this case, the surviving spouse resident in Switzerland requested to have applied a reduction which would be identical for the real or for the property located in Switzerland as applicable or for the real estate or the property in the country of origin. Another aspect is given by the situations where the European Commission in infringement procedures sees the Court of Justice to find that certain provisions of the tax legislation would breach the free movement of capital, namely there are the decisions against Germany and the decision against Greece, whose purpose was to eliminate discriminations included in the tax legislations of those countries. All these infringement procedures can be followed on the European Commission's website. Also, there are two cases when Germany and Italy amended the legislation which had discriminating provisions, and here the proceedings stopped. We are going to analyze now in what succession situations we speak about international taxation. First of all, we need to emphasize that such a succession with cross-border elements, as referred to by Regulation 650, this is different from the notion of international succession, taken into account for the purposes of the enforcement of Article 63 of the treaty. If we analyzed case 25 per 2010, we'll see that the international nature was given only by the residence, namely of the headquarters of the legatee, which was placed in a different member state than the country of the last habitual residence of the deceased, and also by the location of the property which was fully located in the country of taxation. This indicates that from the viewpoint of a possible succession procedure, for a notary public, this case would have a national or domestic character, because the applicable law would be the Belgian law, and which applied to an estate located exclusively in the Belgian state, where probably there was an authority exercising the profession in matters of succession. I must say that, as far as I could find, in Belgium, the notary should intervene in succession cases only if there is an international will or a signed will involved. Therefore, the international taxation of a succession may differ, and it may be larger than in the situation of a truly international succession in the notion emphasized by Regulation 650.
What is found at the level of taxation of the member states? Well, these aspects are taken over from the EC's recommendation dated December 15th, 2011, regarding the avoidance of double taxation. Now, in member states, there are several connecting factors to apply taxes for successions. On the one hand, you have the personal connections, that is, the connection of the deceased or of the inheritor with a certain member state. This personal connection can rely on residence, domicile, permanent residence, the center of the vital interests, the habitual residence, the nationality, or the registered office. All these notions will be defined by the internal legislation of the member state, which applies that taxation system. Therefore, the option that only one succession be applied to the tax law in several member states may also stem from the different construing of the terms of those connecting factors of that case with respect to the state that applies the taxation. Also, a specific situation is given from the location of the estate on the territory of the taxation state, with cases in which this taxation depends on the location of the estate, although the deceased or the inheritor has nothing to do with the, or no personal relation with the state applying the taxation. Now, looking into the international taxation, specifically in the practice of Romanian public notary, for example, we can conclude to two options, two versions. One would be when an international taxation situation occurs during the procedure of issuing a European certificate of succession. Now, this is the situation in which you have a national certificate of succession, but there are certain aspects of international law that are dictated by the relations of those inheritors with another state, then opposed to the one in which the procedure was carried out. As we all know from the content of Regulation 650, we can identify 4 cases in which the notary has jurisdiction to issue the European certificate of succession. The notary or another authority with jurisdiction as performed by the member states, for example, those notices regarding the authorities that may issue a European certificate of succession. The first matter of jurisdiction provides from Article 4 in the regulation when the authorities in the member state where the deceased had their habitual residence at the time of death have jurisdiction to decide on the succession overall, so in its entirety. In this case, for example, a Romanian notary. The Romanian notary determines the law applicable for succession. This will be the Romanian law, except if the deceased chose the law with respect to its law of citizenship, and will handle the situation issuing an ECS, the European Certificate of Succession, also determining the shares which will apply to all property irrespective of the place of location. Obviously, the matters of international taxation in this case are quite complex because the notary will have to become aware and to inform the beneficiaries on the content and the tax regulations depending on all connecting factors which may be taken into account in the case. A second situation would be the one provided by Article 7, letters A, B, or C in the regulation, in which the deceased chose the law, and between the inheritors we have an agreement of selecting the law, or there is an issue of jurisdiction between the court notified from the last state of residence of the deceased as opposed to the deceased choice of law. The Romanian notary or any other authority informed in this case will have jurisdiction also with respect to the entire succession, and the same international taxation aspects will apply as if jurisdiction were based on Article 4 in the regulation. If, on the contrary, the jurisdiction of the authority to issue the ECS relies on Article 10, paragraph 1, letters A or B in the regulation, in this case, the jurisdiction stems from the presence of property of the deceased on the territory of the member state, complemented by the fact that either the deceased had nationality of that member state, or not having nationality of that member state, it had their habitual residence in that member state, and starting with the date when they had changed the residence and until the notification of the authority, less than 5 years had elapsed. In such a case, the authority will also have jurisdiction with respect to all properties in the estate, irrespective of the location, and of course, the international taxation aspects will be those applicable in the first two cases. For the separate scenario of Article 10, Paragraph 2, where no court in a member state has jurisdiction pursuant to Paragraph 1, then the authorities in the member state where the deceased has their property will only have jurisdiction rule on those assets. In this case, the international taxation could again stem from the residence of the beneficiaries of that estate. The last scenario of jurisdiction, according to Article 11, is the forum necessitatis. This is less likely to occur in the notarial practice, but once again, the jurisdiction applies to the entire estate. Now, as I showed in the beginning, the matters of international taxation can also apply when the procedure, from the perspective of the applicable law, has a national perspective. The authority applies its law. The certificate doesn't have cross-border elements with respect to the habitual residence of the deceased. However, certain assets from the estate are located outside Romania. In this case, the Romanian notary, since they do not have jurisdiction on these assets, the matters of taxation to issue the national certificate of succession will only regard certain taxation rules that the state of residence of the inheritors would provide for. We can find in all these matters of succession that the inheritor may be disadvantaged to not benefit in the state where the taxation is applied, where the inheritance document is issued, from the same tax tax exemptions or deductions that would be applied by the other state. Or they might find that several states of the European Union might tax the same estate. This possibility also stems from the fact that in the EU, not only the calculation differs with respect to succession taxes, but the term itself of succession tax differs. As we will see throughout this presentation, in Romania, the succession tax is under the income tax, and it's not the same for other member states in which the succession tax has a different term or is included in another category. Let's take 3 practical cases which will clarify how certain succession may be taxed. For example, the deceased, AB, is a Romanian citizen, has the last domicile, and I will focus on domicile because as I will present it under the fiscal relation, the domicile in Romania is important to determine the taxation laws. Although under the civil law and in private international law, as far as succession goes, what matters is the habitual residence of the deceased. Coming back to the idea. So, AB is a Romanian citizen with the last domicile and habitual residence in Romania. The estate is located exclusively in Romania, but he has 2 inheritors, 2 sons. One is a Romanian citizen with a residence in France, and another son is a Romanian citizen with the residence in Luxembourg. It is clear that this succession will have the Romanian law applicable. The Romanian law is the one that will determine the inheritors and the shares that they will receive. However, each of the inheritors has personal links with another state. One of the sons has links with the French state, with the residence there. The other son with Luxembourg. In this case, the taxation will have to be considered not only from the Romanian tax law perspective, but also in the case in which the inheritors might be taxed in their states of residence for the same inheritance. The inheritor with the residence or fiscal domicile in France will be taxed for all movable or immovable property in France or abroad received from a deceased with a fiscal domicile outside France. These are the provisions of Article in the 750 in the General Taxation Code. However, the son with the fiscal domicile in Luxembourg will not be taxed for property outside Luxembourg, although in Luxembourg the succession tax does exist, and this regards those that property situated on its territory. And for deceased domicile in Luxembourg, the property located abroad will not be taxed, and in certain cases not even the movable property will be taxed. We could wonder in this case whether between the inheritors there is a discrimination relying on their fiscal residence. The European Court of Justice has already showed that the disadvantages that can stem from the parallel use of fiscal jurisdiction in different states, if this is not discriminating, do not limit the freedom of movement. This case, for example, AB was married with CD, both Romanian citizens with the habitual residence in France. Married, however, under the marriage law applied in Romania. Upon death, the AB's estate consists of movable and immovable property located in Romania. AB has one child, EF, Romanian citizen with the residence in Romania. The applicable law of AB's succession is the French law, as the law of the last habitual residence of the deceased. The jurisdiction to issue an ECS belongs to the French authorities. However, as the regulation provides, issuing a European certificate of succession is not mandatory. The inheritors may choose to perform parallel procedures with national and abroad, and to receive national documents depending on the location of the estates. If inheritors were to use this option, and in Romania the succession were debated 2 years after the death, the tax paid in Romania will be deducted from the tax applied in France. These are the provisions of the French fiscal law. Both France and Romania are entitled to apply taxes to the succession. If the deceased were domiciled in France, all movable or immovable property located in France or outside will be taxed. For as a law provides a certain succession for the surviving partner or spouse, but for the direct heirs, the fee may be included between 5 and 45% if the estate exceeds 1.8 million euro. In the third situation, in which AB is a Romanian citizen with the last habitual residence in Romania, with heirs a son, a Romanian citizen, with the residence in Romania. In the estate remaining or left by AB, we have money deposited in an account opened in France. From this perspective, with respect to the applicable law, the Romanian law is the one that will determine the heirs and the shares, also the other aspects of the succession. From the taxation perspective, we will find that both countries are allowed to apply taxes to the succession. The property in France will be taxed in France, although the donor or the deceased did not reside in France. We find in an international succession that we have very many applicable laws. We can have several fiscal laws as proven in the examples above, but also given the essential elements to be regulated upon issuing an ECS or a national inheritance document, we see that they are quite complex, and we can find that certain aspects do no longer apply to the succession law. We have the law regarding marriage. As we know, in the member states, the international law of each state applies, and for the states belonging to or that do apply the regulation 2116 per 2003, these provisions apply to people that will marry after the 21st of April 2019, or to assets in the included in marriages occurring after this date. If the deceased chose the applicable law, this will no longer be determined by the authority with jurisdiction. In all other cases, the notary or any other authority with jurisdiction with respect to succession will have to apply the succession law. Another law that could be applicable, the one regulating the substantial validity of a provision for death or on an agreement with respect to a future succession, are the following, and we will see that this also has indirect effects with respect to fiscal issues, because certain institutions may be qualified as falling under Article 3 in the regulation with respect to a future succession, and to be taxed, or such an institution may not be considered an agreement with respect to a succession, and in this case the deceased plans better, fiscally speaking, the inheritance as a result of death. Also, although the applicable law was determined, it is possible not to enforce it if it is a foreign law that has provisions which breaches the public order of private international law, and also if we have several laws applicable. Another situation would be of the provisions of Article 30, special laws or rules regarding succession restrictions, or which impact succession under various aspects. Briefly, what are the principles of applying taxes to successions in Romania? The system in Romania starts from the definition of the taxpayer. This is included in Article 58 in the Fiscal Code. From the content of this article, the taxpayer is both a resident individual and a non-resident individual receiving income stipulated in Article 129. We have to determine what resident means from the fiscal point of view. This issue has to be differentiated from the residence of a person. A residence which, according to the private international law, falls under the article in the 250 and 2570 in the Civil Code, or in Article 88 in the Civil Code. From a fiscal point of view, a resident is the one that meets at least one of the following terms, and these are stipulated in Article 7.28. Their domicile is in Romania, or the center of interest is in Romania, or is present in Romania for a period or several periods that exceed 183 days in total within an interval of 12 consecutive months, or is a Romanian citizen working abroad as a civil servant or employee of Romania in a foreign state. The fiscal code also defines the matter of the term of center of vital interest in point 6 of the same article, being the place where the economic and personal relations of the individual are closest to. In this case, the family of the taxpayer will be reviewed, but also the contributions that that person made in Romania. What are the income categories subject to income tax? Income from the transfer of immovable properties, as defined in Article 111, and which in paragraph 3 has the principle of succession tax under the name of transferring ownership as inheritance. The Romanian practitioners know this article very well, and this stipulates that the succession is taxed only if the succession was not debated within 2 years from the death of the deceased. If the succession is not performed, the taxation share will be 1% of the estate, the value of the estate, provided that the methodology or the implementation guidelines of the fiscal code stipulate that the assets in the estate, fiscally speaking, only include the real estates. The question that stems is whether this reference only includes the real estate on the Romanian territory, or also regard real estate outside Romania. In order to clarify these aspects, we have to use Article 59 on the one hand, defining the scope of the taxation. In paragraph 1, it stipulates that the taxation in this title, that title refers to Title 4, which is income tax, and it also includes Chapter 9 regarding the tax applied to real estate transfers. So within this tax, we have for the individuals, Romanian residents domiciled in Romania, the income from any source, both in Romania and outside Romania. Also, for the individuals, residents other than those mentioned at letter A, the income from any source will be taxed starting with the date when the persons receive the capacity of residence.
Persoanele fizice nerezidente,
non-resident individuals that meet the residence conditions in Article 7, letters B, C, or D, will be subject to the income tax only starting with the date when they become residents in Romania. One exception would be for individuals proving to be residents of states with which Romania has protocols to avoid double taxation, and the provisions in the Convention will apply to these individuals. We highlight that according to Article 7, an individual, Romanian resident, domiciled in Romania, proving to have changed their residence to a state with which Romania does not have a protocol to avoid double taxation, is obliged to pay income tax for income acquired from any source, both in Romania and outside Romania, both for the calendar year when the residence is changed and for the following 3 calendar years from the date of change. Considering the above, we can distinguish 2 situations. One regards those heirs that are fiscal residents with a domicile in Romania. In this case, the net assets from real estates will be taxed from irrespective of the location. This comes from applying Article 130, paragraph 1-2 in the Fiscal Code regarding the income acquired from abroad by certain categories of individuals. Obviously, only if the succession did not occur within 2 years from the date of death. The second issue regards the non-resident individuals that meet the conditions of Article 7.28, letters B and C, that will be taxed as the fiscally resident heirs domiciled in Romania from the date when they become residents. With respect to the fiscally non-resident heirs, only the net assets from real estate properties will be taxed located in Romania according to the Article 129 in the Fiscal Code regarding income obtained in Romania. Of course, provided that succession was not settled within 2 years. For the heirs with a fiscal residence in states with which Romania has protocols to avoid double taxation, in principle, the taxation laws in those conventions will apply, and they will only be taxed in their state of residence. Another example, which is quite illustrative for the situation of international succession. AM is a Romanian and Belgian citizen with the last habitual residence in Brussels that passes on the 1st of March 2016. The Romanian death certificate does indicate the latest domicile in Ploiești in Romania, which comes from a valid ID from Romania, although they had the last habitual residence in Brussels. The surviving spouse is a Belgian citizen with the residence in Brussels. The deceased had a daughter, a Romanian citizen, domiciled in Romania. The estate includes a bank account and an immovable in Belgium, a vehicle, and a summer house in Romania. The heirs already prepared a document, an inheritance document, submitted to the Belgian fiscal authorities for the taxation of that inheritance, and have declared all assets belonging to the estate as well as their value. And this also included the assets in Romania. The inheritors paid the tax set by the Belgian authorities for the succession of the deceased. Now, the first question regards the law applied to succession, which is the Belgian law. Another question is, what is the value of that, or the validity of that legal document prepared by the fiscal authorities. With the notices performed by between the member states, we discovered that in Belgium, the jurisdiction for issuing an ECS belongs to the notary, irrespective of the name of that document prepared that the inheritors have received in the fiscal authorities. This was not a European certificate of succession, but a fiscal statement. Now, if the heirs were not to receive a document issued by the Romanian authorities within 2 years from when the succession was initiated, would they be obliged to pay the succession tax, and in what conditions? Now, given that when the fiscal code entered into force, the presumption of the European certificate of succession was not taken into account, we can state that any document which, based on the regulation, is binding in the member states will meet the requirement for settling the succession within the 2 years period. In this case, if the heirs receive an ECS from the Belgian competent authorities, they will not be forced, or they will not have the obligation to pay the succession tax in Romania amounting to 1%. Also, for immovables in Belgium, only the daughter, Romanian citizen with the fiscal residence in Romania, would have the obligation to pay taxes that also considers the value of the property in Belgium.
What is the role of the notary when the parties express options related either to the civil law or international private law producing fiscal effects? First, we should analyze the choice of the law applicable to the matrimonial regime and the conclusion of a matrimonial settlement. In this case, the choice may have more advantageous fiscal consequences for the parties involved. For example, if the spouses had the option to choose the French legislation as the law applicable to the matrimonial regime, and in the matrimonial settlement they had a precipitate clause according to the applicable French law, this is considered a matrimonial advantage. This is outside the scope of the tax on succession, which means that the rights received by the surviving spouse will not be subject to taxation according to the French law. On the other hand, if the same clause had been stipulated in a matrimonial settlement concluded in Romania with the application of the Romanian law, we might have raised the question whether the transfer has a successoral nature, because there are opinions related to this type of clause as contractual clause. So the simple qualification of this clause based on one of or the other of the possible legal options would lead to different consequences. The French administration has considered for quite a while that the assets received based on this clause should be taxed according to the succession taxation. Currently, this does not have a significant importance, because the surviving spouse is not subject to taxation anymore. But regardless whether the applicable law is Romanian or French, the goods acquired by heirs following the exercise of reduction would fall under the scope of succession tax. The same situation can be presented for the French legislation allowing for the for a clause providing that persons married under the separation of assets would provide that the property bought on the territory of France would, after the death, would be the property of the surviving spouse. So this would no longer be part of the estate and would no longer be subject to taxation. Regarding the choice of residence of heirs or the choice of domicile, such options, it is more difficult to exercise such options. They are not part of the options which are under the jurisdiction of the notary, similarly to the movable or immovable contents of the estate, but they may create fiscal effects. For example, in the Romanian law, in case of reduction, this will be in kind. In case of reports, that would mean by equivalent, and only in certain cases this can be made by the beneficiary in kind. If we have such a reduction or report, the part of the goods which were considered excessive will re-enter the estate and will give rise to the possibility of taxation, especially when reduction was performed as following an action in court. It is very likely that the duration of the trial would exceed the 2 years for solving the succession case. What is the role of the notary in terms of knowledge on fiscal matters? In an international succession case, the notary has to have knowledge both on the taxation principles related to the personal connections of the heirs or of the deceased, but also regarding the location of the property. They also need to know the regulations on avoidance of double taxation and the obligations to make statements for heirs. In this matter, we may only indicate 2 decisions passed in France. The first one is related to a inheritance situation. In that situation, the deceased, it was a widow with 2 children. The widow was notified by the French fiscal authority to submit the succession statement within 6 months. She notified the notary public and asked him to draft the statement and deal with the succession and submit the fiscal statement. The notary public cooperated with the financial institution which owned the financial property left by the deceased, and indeed from the case it resulted that their action was delayed. However, in any case, the notary public had the obligation to inform that person on the consequences of failure to submit a statement to the French fiscal authorities within 6 months. The beneficiary, the surviving wife, was obliged by the French fiscal authorities to pay more tax by 40%, and then she sued the notary, a civil case. Without getting into details, we need to emphasize that starting with 1960, the French Court of Cassation found that the notary public has the obligation to inform and may not defend themselves by saying that their activity is strictly limited to authenticating the will of the parties. The French doctrine appreciates that the documents and their sufficient and nature should also include the fiscal law. A second, more recent situation indicated by the French case law is a situation which is not related to succession tax, but could always be transposed in a situation of taxation. Namely, it is a couple. They lived in France, then they changed their residence for Sweden following a professional change, and they decided to sell an apartment which had been the main residence in France after they left for Sweden. When they approached a notary, their first concern had been to know whether they would benefit or not from an exemption applied in France for the main residence. The answer of the notary public following a consultation with the French authorities was that although they had changed their residence and they had no longer been living in that building for months, this exemption related to the sale of the main residence does apply. They sold the property. After moving to Sweden, the couple found that the income from the sellout would be taxed in Sweden, and then the notary showed that the payment of the tax is due to undue exercise or improper exercise of the obligation to inform without analyzing all the details of the case. The French Court of Cassation showed that the obligation to pay a tax may be considered damage subject to payment of damages, and the case would be solved by the Court of Appeal. But in this case, any practitioner would wonder whether indeed, if the parties had known that this transaction would be fulfilled and taxed in Sweden, whether they would have given up their intention. In matters of inheritance, it would be more difficult to believe that the parties would give up inheritance if the taxation in their state of residence would be quite burdening. However, the notary does have the obligation to at least inform the client on possible taxation of that transfer in another country as well. Thank you. These were the main topics I wanted to tackle for this morning, and I am available for questions either now or at the end of the seminar. Thank you.